This is estate planning attorney Jason Lindamood, and today we are going to talk about what the difference is between an heir versus a beneficiary. Now, these are a couple of terms that are sometimes used interchangeably, and while there's often quite a bit of overlap between these designations, there's also some important, subtle, nuanceable differences that may come up depending on our situation. So a simple way to think about this is that an heir is someone who would inherit by law if there's not a will. So if we don't have a will, this is typically going to be our spouses, our children, our grandchildren, and other relatives, typically based on how closely related they are to us. And state law determines the priority of who gets what for us on our behalf. So if you die intestate, meaning without a will, your heirs are the people who would automatically inherit your estate. On the other hand, beneficiaries are people who are named in your will and who are going to be the people who will ultimately be the ones that your property is left to based on your wishes. So if you have a will, it's much better to be a named beneficiary than an heir. Because remember, an heir is simply the person who would inherit if a will did not exist. Make sense? So bottom line, it's always a good idea to put our intent and our wishes in the form of a will or a trust, because it allows us to have the choice as to who gets our estate. It gives us a choice as to how they get it. And it keeps the laws and the regulations of the state from realistically overriding our wishes potentially. So yet another reason why having a will and overall having a really good estate plan, thinking ahead a little bit, is super important. That's all I have for you today. If you're in a position to hit a like button, leave a comment, or share this with somebody, that's always greatly appreciated, and I'll talk to you again soon.